of 5G and cyber, I think we could easily spend an entire day just on that topic alone. Now, our next panels will be discussing rules of, thank you, rules regarding the rule of law in the 21st century. Incredibly important in these very difficult and challenging times. So what we'd like to do now to reinforce those tenets is to revisit the remarks of Justice Breyer. So if our audiovisual people could please run the video from yesterday of Justice Breyer. Thank you.
Describe to me your love with the rule of law. So what is the rule of law for you?
The rule of law is tough. I found out a very good statement. We had a very good conversation. A woman who is Chief Justice of Ghana shows up in my office in Washington, and she's trying to do very good things. And I think she's been successful in part in trying to make the system more responsive to democratic imperatives, protection of human rights, and so forth. She asked me this question: why do Americans do what you say? That's not such a bad question. And it's really a question of custom and history. And there have been times when they haven't. And we've had civil wars, as you well know. And we've had slavery, and we've had all kinds of things. So the best that I could do was to tell her a few of those things and say, over a long time, you can develop habits. But the important thing is for the citizens who are not lawyers. You know, we have 331 million people in the United States, and 330 million people are not lawyers. And those are the people who have to decide that they will follow the law and what judges say, even if they think it's wrong. And is it wrong? Yeah, sometimes it is wrong. If we have a 5-4 decision, somebody's wrong. And you like it? No, I don't like it. You don't want to follow it? Yes, I don't want to follow it. Will you follow it? Yeah. When they're willing to say that, because they see the alternatives are worse, because they look at television and see what happens in countries where they don't say that, at that point, we have the beginning of a rule of law. And so you have to convince, and the lawyers have to convince. The judges, they can't convince anybody because they're self-interested. But the lawyers can, and the others can. Hey, Mr. Person in village, Mr. Person in the town, men and women in cities and towns who are not lawyers, it's in your interest. It's in your interest to follow a rule of law, and that means agreeing with cases or following them even when you don't like them. When you have that, you begin to have a rule of law. And when you have that, you begin to have a weapon that can be used against people being arbitrary, capricious, dictatorial, etc.
Brilliant. So, Justice Breyer, my friend, let's talk in Madrid if it's possible. And thank you so much for your time.
Thank you.
Thank you.
Moderating our next panel is José Igreja, the first Vice President of the International Association of Judges and President of the European Association of Judges. We have a truly distinguished panel of jurists, and I will read from this. It is my honor to present these jurists, including Luz del Carmen Ibáñez from Peru, Vice President of the International Criminal Court, Baltasar Garzón of Spain and Trustee of the World Law Foundation, Santiago Muñoz Machado, also of Spain and Director of the Royal Spanish Academy, and Leonel Fernandez, former President of the Dominican Republic. Our first speaker this morning is the Honorable Julio Scherer, Legal Counsel to the President of Mexico, who will be participating by video.
Gracias, gracias. Ayúdame.
Baltasar, sí. Luz de Carmen Ibáñez, por favor.
Es que no puedo.
Y Leonel Fernández. Sí, es fuerte.
¿Y dónde está?
Leonel Fernández, por favor. Muy bien. Vamos a oír ahora por Zoom a Julio Scherer Ibarra, que ha sido anunciado ya y pedía para que pasaran el Zoom. Ahí está él. Buenos días.
Me
Que
toca
no
hablar
tiene
sobre
sonido. Sí.
el Estado de Derecho en el siglo XX. En el curso de los años, y por lo menos un par de siglos atrás, los juristas, los politólogos y filósofos hemos venido construyendo el concepto de Estado de Derecho. A partir de una primera idea, el concepto fundamental de Estado de Derecho, a saber, es aquel que en todos sus actores se sujetan al gobierno y al cumplimiento de la ley. Creo que podemos coincidir en que para fines del siglo XX existía ya un razonable consenso en la comunidad internacional sobre una serie de requisitos que se tendría que verificar en un Estado para poder reputarlo como Estado de Derecho. Por ejemplo, la existencia de límites y contrapesos al poder gubernamental, la obligación gubernamental y personal de rendir cuentas, la exigencia de un gobierno suficientemente abierto hacia la sociedad y libre de corrupción, el reconocimiento y la protección de derechos fundamentales dentro del Estado y la existencia de instituciones y procedimientos accesibles e imparciales para la creación y aplicación de la ley. Sin embargo, soy de la opinión de que esta tradicional concepción del Estado de Derecho, que es de tipo formal, resulta hoy incompleta, pues sin un mínimo de igualdad social, el Estado de Derecho se hace inviable. Aunque seamos todos iguales ante la ley, en la pobreza no hay manera de contratar un abogado. Si todos somos iguales ante las instituciones del Estado, todos los procesos deberían de terminar hasta su última instancia. En México, por ejemplo, por esa desigualdad que todavía nos agobia, más del 60% de los procesos termina en primera instancia. Resolver la justicia del día a día es regresarle al pueblo el Estado de Derecho. En México, el presidente de la República, López Obrador, está haciendo un esfuerzo enorme por llevar a cabo un proceso de transformación social que nos lleve a acabar con la corrupción y hacernos a todos iguales frente a la ley. Que no se permitan diferencias entre los distintos grupos sociales y que la igualdad jurídica siempre sea un presupuesto en el Estado de Derecho. De acuerdo con nuestra concepción tradicional, si en un Estado, entre otros presupuestos, se aplica y se respeta la ley, se consagran y se respetan los derechos fundamentales Existe rendición de cuentas, la sociedad tiene acceso al gobierno. Los gobernados pueden acceder a los mecanismos de acceso a la justicia y se conducen de manera imparcial, podemos razonablemente hablar de un Estado de Derecho. Pero en México, desafortunadamente, solo vamos a hablar de un Estado de Derecho real y formal, sobre la pobreza, la ignorancia y la marginación de una parte importante de la población. Entonces sí estaremos atendiendo a un mínimo estado de bienestar y de derecho. En México aspiramos y estamos trabajando para ello, que todos tengamos acceso a un abogado, así sea pagado por el Estado, que tengamos acceso a las instituciones y que por esta vía tengamos acceso a la justicia. Con un acercamiento eminentemente formal al tema que nos ocupa, se ha venido afirmando una y otra vez con insistencia que no hay Estado sin ley, que sencillamente no podemos hablar de Estado de Derecho si dentro de este no gobierna la ley. Pero realmente muy poco gobierna la ley en aquellos estados en donde, a pesar de que existen formalmente las instituciones, las medidas, los procesos y los principios correspondientes, buena parte de los gobernados viven realmente al margen de estos, debido a su muy precaria condición social. Para que realmente se cumplan buena parte de los que hasta ahora hemos entendido como presupuestos de Estado de Derecho, tiene que haber dentro del mismo un mínimo de equidad. De hecho, debido a ello, ese mínimo tendría que entenderse igualmente como un presupuesto más hoy del Estado de Derecho, y así lo estamos planteando en México. En todo caso, y al margen de la discusión jurídica y política sobre Estado de Derecho, lo cierto es que podemos ver hoy, alrededor del mundo, múltiples esfuerzos nacionales por tratar de lograr sociedades más equitativas y homogéneas. Celebro enormemente estos esfuerzos y confío en ellos, del mismo modo que en un futuro cada vez más solidario, que nos permita ver el paso de algunos años, no solo naciones, sino una comunidad internacional cada vez más igualitaria. Pero para lograr este objetivo, todos tenemos que poner de nuestra parte. Cada individuo y cada nación tienen que hacer lo propio. Por lo que a mi país respecta, me siento orgulloso de ver un gran impulso en esta dirección, gracias al esfuerzo que hace esta administración, encabezada por el presidente Obrador, que se ha imaginado precisamente esto, una sociedad mexicana cada vez más solidaria. Muchas gracias por su atención. Muchas gracias por permitirme esta participación. Buenos días.
Okay, thank you. Let's start our panel. We have here two distinguished panelists, and we have already one on Zoom. First of all, a brief word of gratitude. I think it was Breyer that said that gratitude is the only feeling, the only sentiment that we cannot have exaggerated. And myself, as president of the European Association of Judges and first vice president of the International Association of Judges, want to express my gratitude to the organizers, to the World Jurist Association, in the person of Mr. Dr. Diego Solana, that is here with us, Javier Cremades, and all the others that are so important, the team that was always with us. It was a great honor to be with you. So let me start with my brief remarks about the situation that we are facing today. The International Association of Judges, just to have a small idea of what I represent here, is the biggest association in the world of the judiciary. We have now 92 countries represented by our organization. We started almost 7 decades ago in 1953. We are a totally political organization, but our main mission, our commitment, continuous commitment, and very difficult in recent years, is judicial independence and rule of law. I will start with a story, a parable of a well-known American writer, David Foster Wallace, with this tragic ending. But it's a very interesting story to understand what represents judicial independence for a judge. There are two young fish swimming, and they meet an older fish swimming on the other side, who nods and says, "Good morning, guys. How is the water?" And the two young fish swim around a little bit, and then finally one of them looks at the other and says, "What the hell is water?" This is a parable. The decisive and important realities are often the most difficult to see or even to speak of, except, obviously, if they became rare or if we lose them. So judicial independence must be seen as our water for us judges. Only if the judges work independently will be finally able to move freely, serving our fellow citizens. And the situation in the world about judicial independence, with all this presence of autocratic regimes, populism, and the crisis of rule of law and democracy, is today of great concern, even of some anguish, to say the truth. And now the pandemic, the dystopian temptations of some political regimes clearly enhanced the problem. So how should we judges approach this role as protectors of fundamental rights and of rule of law? I have three very brief notes to share with you. First of all, judges must avoid the populist trap. We must keep the discussion on a juridical level. You can disagree without being disagreeable, to quote Ruth Bader Ginsburg. Second, the concept of judicial independence is not open to discussion. This is not open to discussion. This is a consolidated concept. We cannot engage in any discussion about rule of law or judicial independence. We should be a little bit orthodox on this issue. The clearest way to show what rule of law means to us in everyday life is to remember what is happening when there is no rule of law, as Eisenhower said in a very difficult time for history in Europe. And finally, the third note. I think, and I wrote about it in several articles, we need a Marshall Plan for rule of law. European judges, especially, would like to perceive the same levels of determination of the Marshall Plan to solve economical problems for the crucial issue of rule of law. Legal professions must work together on this. Real change, enduring change, happens one step at a time. And I'm quoting again Ruth Bader Ginsburg. Los tiempos difíciles actuales exigen de nosotros, instituciones internacionales, una voz firme, valiente, resiliente. La globalización de los problemas, con las redes criminales transnacionales, regímenes autocráticos, nacionalismos extremos, corrupción, que es un problema gravísimo que enfrentamos, incluso en el judiciario, requieren respuestas también globales. Voy a daros un ejemplo muy concreto que está un poco minando la confianza de los ciudadanos y nuestros jueces. Hablo del nombramiento de jueces para Cortes Supremas y de vocales para consejos de magistratura, consejos judiciales. Es un proceso extremadamente politizado hoy en día en que los criterios de mérito, la meritocracia, ha perdido espacio y hoy está más concentrado en razones políticas que es muy difícil entender. En este entorno, organizaciones como esta, las asociaciones de jueces también, los abogados, tienen un papel insustituible. Todos nosotros existimos también para contrariar la solitud, diría, genética de los jueces, que tienen que decidir sus casos siempre solos delante de la ley y de su conciencia. Termino con una historia. Piero Calamandrei, el gran jurista italiano, en el espantoso caos de un mundo en ruinas, hablaba en 1943, y este año no lo he escogido por acaso, porque estamos otra vez en Europa en esa encrucijada hasta el futuro. El Estado de Derecho es un método de gobierno, y escribió un pequeño libro que se llama Sin legalidad no hay libertad. Eso ha dicho Calamandrei en 43. Ortega Gasset dijo, dime a qué prestas atención y te diré quién eres. Este es el momento para prestar atención al Estado de Derecho, a las cuestiones de la independencia de los jueces, y si prestamos atención a esto, todo lo demás será más fácil de manejar. Muchas gracias por vuestra atención. Thank you very much. Bueno, y ahora voy a vestir el otro ropaje que me han investido y voy a presentar a mis queridos amigos y moderadores que conozco hace tiempo, a Baltasar, hemos coincidido algunas veces, y a Luz de Carmo Ibáñez también en un panel online, si recuerdo bien. Bueno, Baltasar Garzón no necesita presentaciones, todos lo conocen, es un distinto abogado y hace parte de World Law Foundation Trustee, is one of the members of the World Law Foundation Trustee. So, you have the floor, Baltasar. Gracias.
Gracias, buenos días a todas, a todos. Gracias por permitir que este encuentro tenga lugar. Supongo que a lo largo de estos 2 días de reunión en este lugar, la palabra pandemia ha salido muchas veces. Desgraciadamente seguirá saliendo durante mucho tiempo. Hemos vivido y vivimos en una situación de emergencia internacional y de emergencia en cada uno de los países, unos con más intensidad que otros, pero todos afectados. En zonas del mundo como Latinoamérica se han vivido estallidos sociales, conflictos, ataques a la paz, golpes de Estado, agresiones a la naturaleza, pueblos originarios, auge de determinados extremismos, populismos, que al final, de una u otra forma, se traducen en problemas jurídicos. Al final, de una u otra forma, los jueces, las juezas, todos aquellos que estamos en el mundo de lo jurídico, resultamos afectados, aparte de toda la ciudadanía. Y en este contexto, la cuestión es qué hace o qué debería de hacer la justicia. Se podría decir, algunos afirman, que hemos pasado desde el gobierno de las leyes al gobierno caprichoso de los jueces, que en muchos casos se extralimitan en sus funciones, la judicialización de la política o la politización de la justicia, que al final casi en los tiempos actuales da lo mismo uno que otro, porque en definitiva es el uso instrumental del derecho desde una perspectiva o desde otra. El uso del poder que tiene el Poder Judicial es el correcto. El presidente de la Asociación Mundial de Jueces mencionaba los consejos de Poder Judicial, los nombramientos de las altas cortes, etcétera. Es decir, es el correcto no quienes designan, sino también internamente. O hay escenarios, esferas que demuestran que va más allá de lo que se le exige. Cuando concurre con otros poderes, como los políticos, los económicos, a veces se ha constituido, se percibe que se constituye en un contrapoder del Estado. Lo hemos visto en Argentina, lo hemos visto en Brasil, lo hemos visto en Ecuador, Bolivia, en otros países de Latinoamérica, no tanto en Europa, aunque algún riesgo se va percibiendo, aunque aquí a la inversa por el auge de la extrema derecha en determinados países. No olvidemos, por ejemplo, el conflicto que ha existido en Polonia con el Poder Judicial y la independencia, o tratar de someter a la justicia al control político. El verdadero papel de los jueces es interpretar el derecho, aplicar la justicia en favor de los ciudadanos y protegerlos de las agresiones. Eso todos los que estamos aquí lo sabemos. Es decir, hacer que la justicia sea justa, equitativa, democrática, independiente, imparcial, protectora del medio ambiente, respetuosa con los diferentes, ecuánime, ética, legal, empoderadora de las víctimas, sin rencor y con todas las garantías para el justiciable. Es decir, esto es lo que yo denomino, sin tratar de dar ningún contenido ideológico, una justicia progresista. Desde mi punto de vista, hoy día no cabe una interpretación del derecho y, por tanto, una acción de la justicia que no sea progresista, progresiva, protectora de estos valores que para mí son fundamentales. No podemos aplicar a la situación que vivimos hoy, como decía al comienzo, de emergencia, normas y reglas y principios que en casos están consolidados, pero que son del siglo pasado o incluso antes. La evolución del derecho ha sido larga y tortuosa, desde los planteamientos más atávicos, pasando por su fundamentación filosófica clásica, continuando por esas épocas oscuras en las que la falta de respeto a los derechos elementales, a los principios del debido proceso, eran una evidencia en regímenes totalitarios o carentes de Estado de Derecho, hasta llegar al desarrollo garantista por medio de jueces y juezas independientes. Esto es lo que no se puede perder y se corre el riesgo de hacerlo si se usa y abusa de la justicia. Hoy día vemos con demasiada frecuencia el uso y abuso de la justicia, sobre todo en el ámbito o en el campo penal. Tenemos también desafíos importantes, los efectos del cambio climático, la destrucción de la naturaleza. Por tanto, es tiempo de que abordemos la necesidad de configurar nuevas estructuras, nuevas definiciones que hagan este equilibrio entre los humanos y la naturaleza sostenible, la definición del ecocidio como crimen contra la naturaleza, la dotación a la propia naturaleza de derechos, es algo que hace unos años pareciera que era algo absolutamente absurdo y que, sin embargo, hoy se está convirtiendo en algo absolutamente esencial ante esta evidencia del cambio climático y los efectos nocivos que al final, como digo y como decía, revienten en actuaciones judiciales, en acciones desde la aplicación y la interpretación del derecho. Se ha mencionado por el doctor Julio Scherer la corrupción. Evidentemente, la corrupción, cuando afecta a estructuras institucionales y esencialmente a la justicia, se convierte en algo absolutamente nocivo, perverso. Y en esto no es suficiente jamás los esfuerzos que hayamos podido realizar. Siempre es una constante, porque siempre habrá mecanismos de ataque sistemático frente a esa pureza que debe de irradiar las propias actuaciones judiciales, porque al final la acción de jueces, de fiscales, de abogados, de los operadores judiciales son el reflejo para la ciudadanía. Los ciudadanos necesitan tener esa referencia. Desafortunadamente, en gran medida se ha perdido respecto de otros colectivos, como puede ocurrir en el mundo de la política. La referencia positiva, protectora, de defensa responsable de los derechos de la ciudadanía no puede perderse desde el punto de vista judicial, desde el ámbito judicial, desde el ámbito de la interpretación progresista del derecho. Y eso ocurre cuando nos enfrentamos a lo que se conoce con el lawfare, las guerras jurídicas que desgraciadamente cada vez con más frecuencia estamos viviendo en diferentes países, en unos más que en otros. Se utiliza a jueces o se dejan utilizar los miembros del Poder Judicial en esas guerras, en esa confrontación política, amparando actitudes y cuando no lo hace se enfrentan a graves consecuencias. Estamos viendo cómo en algunos países, como Brasil, por ejemplo, está en cuestión toda lo que fue una operación de investigación conocida como Lava Jato, etcétera, todo en cuestión porque probablemente se ha hecho uso, ese lawfare, esa guerra jurídica en contra de oponentes políticos. Sí serían muchos los casos, por tanto, este es un gran desafío desde mi punto de vista al que nos enfrentamos. Porque el derecho y la justicia, queridos amigos y amigas, es patrimonio de todos y cada uno de nosotros. Es la convocatoria a la lucha por el derecho de la que hablara Yering, en la que no tiene cabida esa instrumentalización del sistema con fines de persecución política o económica. Este es el reto. Decía Julio Scherer que sin igualdad social el Estado de Derecho no se hace viable. Suscribo total y absolutamente esta afirmación. La igualdad se tiene que predicar, la defensa de los más vulnerables es una obligación como víctimas de la justicia y no con ello se altera el debido equilibrio y el debido proceso y las garantías de quienes son objeto de una investigación penal. La defensa de los derechos de la mujer. Tenemos de una vez por todas que introducir esa perspectiva de género dentro del ADN del sistema judicial de todos y cada uno de los países. Mientras que esto no se haga, podremos seguir hablando indefinidamente del rule of law y de todo lo que debemos hacer y no llegaremos casi a ningún puerto. Muchas gracias.
Muchas gracias. Palabras importantes, la cuestión de género, que es una cuestión decisiva para los tiempos futuros. Y pasaría la palabra inmediatamente a la doctora Luz del Carmen Ibáñez, que, como todos saben, es vicepresidente de la Corte Internacional Penal y que ha sido medallada ayer, muy justamente. Es un honor tenerla con nosotros como panelista. Tiene la palabra.
Muchas gracias por la invitación. My participation will be in English. At the outset, I want to thank the organizers of this event that gathered us to discuss such an important topic that is a key for the peaceful coexistence of humanity. The 21st century ought to be the time for the prevalence and full enforcement of human rights and, accordingly, the rule of law in the 21st century must reflect this idea. It must encompass all of the challenges of globalization and pressing social problems such as migration, extreme economic inequalities, differences between the global north and the global south, unresolved problems of discrimination and inequality based in origin, race, religion, and above all, gender. It must tackle the intersectional inequalities that women around the world continue to face in relation to men. Given my role as an international judge for the past several years, I will focus my analysis primarily on the international rule of law. Certainly, being a judge is a job and a mission that entails a very difficult work to enforce the rule of law and to hold subjects accountable. I note that independence and impartiality and the appearance of independence and impartiality must be enhanced in the new international rule of law at all levels. The rule of law of the 21st century could be envisioned as a rule of justice that fosters sustainable and durable peace. In the 17th century, Hobbes posited that the rule of law protected individual liberty in a state of chaos. In the same century, Locke expanded the concept to represent the protection of a man's inherent right to freedom from other men and from the power of the government. In the second half of the 19th century, Albert Ben-DC emphasized that legal equality was the key of the rule of law, asserting that no one is above the law. The basic concept still underpins the rule of law to this day. However, it needs to be developed according to the new realities of our times. But the question that here arises is, which law? This question is especially important in the realm of international law. It is precisely in this context, that we see international law made by the global north, mostly with the standards and visions and directions of this region of the planet. We must regard this, or maybe the law enacted by men only with male standards and male conceptions? Or do we need a broader understanding of the law, especially in international law? These questions lead us to look the answers that can be found in a diverse, inclusive, and broad vision of the law, which could lead us to a new structure of the rule of law. Here, I propose certain elements that should be taken into account for the ongoing strengthening of the international rule of law. First, we must assess the law relying in international recognized human rights as the central axis. As you know, there are entitlements preceding the law. As the blueprint, it must be law that consecrates equality and inclusivity. It must be law that secures the rightful equal place of women in society. So, while legal equality, or the equality before of law, remains the fundamental principle of the rule of law, it is the content of the law that must evolve. We saw in the 20th century the evolution of the international law and how it shifted its attention from the state-centered to be an individual entitle the individual as subject of rights and obligations and standing before the international law and international courts. This evolution was accompanied by the creation of a number of international human rights and treaties that protect individuals with forums and with a number of guarantees for the protection of their liberty. Now, the current status of the question. Regarding the current status of affairs, domestically and internationally, the current reality is characterized by endemic segregation and discrimination. Despite remarkable progress in science in many states, such progress has not been evenly shared. We see healthy, educated children in some parts of the world, and food and security, lack of shelter, and lack of access to education in others. Although in theory we are equal, in practice we do not enjoy the same rights, be it because of the place where we were born, the color of our skin, our sex, our religious beliefs, or other affiliations. Historically, and today, the world has also been divided along gender lines. Women have been treated as lesser, and they have not been afforded an equal place in society. All of this threatens the true concept of the rule of law. What is the role of international law with respect to these grave, deep-rooted inequalities? The shortcomings of the ongoing project of international law have been highlighted by many, including, for example, scholars of the Third World approaches to international law, the Z12 movement. A perspective from the Global South questions the role of international law in maintaining the unequal structures and processes that further divide Global North from the Global South. While international law claims to be neutral and universal, its creators have asserted their European or Western origins. This continues to be the main idea of what we know today as international law. It appears that it can hardly be understood as truly international as long as it does not rely on universal views, but on a view that ignores the richness of diversity of the world. For this reason, international law must evolve to consider broad new concepts that encompass the diversity of the global population, its perspectives and interpretations of the law. The views of the South are as valid as those of the North. It must be ensured that women participate in shaping the international rule of law, which must in turn be based on gender equality. In Justice Ruth Bader Ginsburg's words, women belong to all places where decisions are being made. It shouldn't be that women are the exception. In this new legal order, gender equality must be based on an intersectional approaches that includes diverse views, equality, not only with a view to achieving the equality on sex, but also to avoid racial, social, and economic discrimination. As noted by Kimberly Crenshaw, the professor who coined the term, an international approach, intersectional approach, is a prism for seeing the way in which various forms of inequality often operate together and exacerbate each other. For these reasons, I believe that a view to strengthening the international rule of law in the 21st century, international law must be progressively applied and interpreted in accordance with human rights. To this end, human rights tribunals have asserted to do so. Particularly, the Inter-American Court of Human Rights, which has applied the principle of evolutive interpretation, or the pro homine principle. The principle of evolutive interpretation is based on the understanding that treaties are living instruments whose interpretations must go hand to hand with the evolving times and current living conditions. In the framework of the ICCPR, members of the Human Rights Committee have noted that the interpretation of a treaty should be performed on the basis of the pro persona principle. Human rights have evolved to be understood as having new content according to emerging realities. We have come a long way since the establishment of fundamental individual rights in French Revolution, which consecrates the principles of freedom and equality as individual rights. Today, human rights are broader and comprehend not only individual and political rights, but much more. The global reality of the last 2 years, which has brought unprecedented global challenges, such as the current COVID-19 pandemic, has posed an unprecedented crisis where solidarity is emerging as the value of the international, that the international community must promote. We live in an age where our global independence is undeniable at this point. Under my vision of the international rule of law in the 21st century, states and individuals in the global north ought to help ensure that individuals in both global south and in global north attain the same enjoyment of their human rights. Any concept of rule of law must be evolving and progressive. Today, it means that it must promote the new value of global solidarity. A comprehensive and broad conception of peace leads us to understand that peace is thicker than the absence of war. It entails the absence of hunger, absence of injustices and inequalities. There cannot be hunger in the global south while there is abundance in the global north. In the words of the 14th Dalai Lama, peace in the sense of the absence of war is of little value to someone who is dying of hunger or cold. Peace can only last where human rights are respected, where people are fed, and where individuals are nations and nations are free. In my view, there's no peace without a fair rule of law. It requires equality in general, especially equality of genders, equality regardless of our race, ethnicity, nationality, religion, belief, opinion, or any other condition. And above all, it requires prevalence of justice, particularly social justice. The rule of law in the 21st century must promote and ensure the absence of hunger, absence of inequalities, and the absence of arbitrariness. In other words, it must safeguard human rights, promote social justice and global solidarity, and foster equality, especially equality for men and women, as a human right for both genders. As expressed by Justice Ruth Bader Ginsburg, I don't say women's rights, I say the constitutional principle of equal citizenship stature of men and women. Gender equality is a right that protects any gender. To finalize, I would like to highlight that justice effectively carried out is one of the fundamental values that must always be ensured and prevail as a source of accountability in international rule of law of the 21st century at all levels of social coexistence. In words of Martin Luther King Jr., injustice anywhere is a threat to justice everywhere. As he noted, the individual is part of an inescapable network of mutuality. There is no global justice if women are not equal members of society. There is no global justice if, regardless of the progress of the science, in some places, most parts of the world lack health and food security. The lack of realization of human rights in the global south ought to be the first point in the agenda of international community, alongside the need to ensure gender equality. In conclusion, I believe that the rule of law in the 21st century must necessarily adopt an evolving interpretation of the law. It must ensure and guarantee the prevalence and full enforcement of human rights, accountability, social justice, equality, and above all, the equality of women in society, both nationally and internationally. The rule of law in the 21st century must evolve to become an international legal order that ensures peaceful coexistence among peoples, states, and individuals, with diversity, racial inclusion, and gender equality as the basis of the true freedom and peace. Thank you. Thank you.
Thank you. Thank you very much for your very interesting exposition. If I may try to summarize your interventions from both of you, I will say 3 or 4 brief notes. The first about gender and diversity, as you very well explained. The second one, the problem of corruption, that was also underlined, and the need to have a concrete international approach to this problem. And finally, to have a more concrete implementation of rule of law. It's not only words, we need to be more active. The recent experience of European Union in linking, in making the connection between financial aid and a chapter about rule of law and the commitment to rule of law could be also seen as a possibility for Central America. For instance, I was talking with a very dear friend from Guatemala and the problems that they have in Central America, for Africa also, to have an international cooperation that is more based on respect for rule of law instead of only economical, technical issues that are only one of the points, but that not the essential one. Y para terminar, les pedía que va a haber un aplauso final, es inevitable, pero quería, con la permisión de vosotros, quería compartirlo con presidente Javier Cremades, doctor Javier Cremades, doctor Diego Solana. El aplauso que va a llegar no es para nosotros, es para ustedes. Muchas gracias.
I would like to thank our eminent jurists for their very strategic and perceptive commentary on the rule of law and what is needed to promote the rule of law, not only just in the 21st century, but into the centuries beyond. We were very, very disappointed that 2 of our panelists were not able to attend at the last minute, but it did give us the wonderful opportunity to listen to the expanded and very excellent commentary by 3 incredible judges. Let's give them another round of applause. We are now going to take a short break. We will be returning at 11:45.